TV. Hi, everybody. I hope everybody is doing well. Today is Super Tuesday. I hope you voted. Now I have that on recording. I can say I hope you voted. I gave an introduction to a speaker on immigration law earlier today, and so I figured that I used that as my introduction then, and I'm using it now, that immigration is a huge issue right now. And I don't care what side of the issue you stand on in terms of discussion, but it was interesting to me how many of the students in the room, and there were, I don't know, 50, 60 students in the room, didn't really care about immigration at all. Like, at all. It was terrifying. And that's not really a cyber law issue, per se, but it's pertinent to the fact that we have elections today, and it's one of the key. Now, I also asked them how many of them were going to vote, and I got about the same number of hands as people who cared. And they weren't all the same people. Like, the people who cared weren't necessarily the people who voted. So, they were undergrads. They were all undergrads, mostly freshmen. That's a large part of it. Okay. I want to talk about Apple today. And I'm going to go ahead and pull up my resource here. If the window sharing, make sure that works. Screen share. There we go. Okay. We're going to talk about Apple today. There's a lot of perspectives. You guys see the screen now? Online, guys, is that coming through nice and clear? Is it usable?
Yes, I can see it.
Okay, cool. All right, so what do you guys know about the Apple thing? Because I figured that would be a great place. I want to start in on privacy and intellectual property, because this Apple case is a case that we're going to see a lot of. It's going to go to the Supreme Court. But I figure we need to talk about, you know, our rights against search and seizure, our rights of privacy, because the right to privacy was only actually finally fully recognized in the 1960s, constitutional, according to Groswald. You guys need to know the case of Groswald. I forget who it was against, because it doesn't matter. Everybody calls it Groswald. G-R-O-S-Wald. Okay? It's Groswald, not Griswold. We're not talking about the National Lampoon's Vacation or anything like that. Was that what?
Was that the one where they were in the phone booth?
Phone booth? No, they were at home. This was about birth control. And about how what you do at home and your sexual reproductive rights being a behind closed doors matter and not for the state to determine what you do at home. Which is very much the way that a lot of these cases have been decided, right? But the right to privacy is only recognized as being a legitimate constitutional basis for a decision since the 1960s in that case. Right? Well, we all kind of take our right to privacy for granted. Yes? Yeah? You have a right to privacy? Your home is your castle. That's a very old, a very British sentiment, because a person's home was the only place in the entire kingdom, now there were many of us places like them, that the king couldn't just walk in unannounced. Right? That's what the constitutional monarchy did and whatnot. You had a right to privacy even in a monarchy where the monarch outside of your home could do anything they wanted, including enact laws that were corruption of blood, etc., right? Remember that little phrase, because that's my favorite phrase in the Constitution. So do you want to start with intellectual property or privacy? Privacy works. Okay. So the crux of the matter is, and I need to kind of survey, but how many of you think that the FBI and the courts are right that Apple should be forced to unlock this phone and all subsequent phones? Which is the San Bernardino shooter's phone in question here. Seriously?
I think so.
Do you think they should have to unlock it? Say it again online, whoever's talking. I heard something. Huh? I thought somebody online said no. Because I need somebody on both sides.
No, there's a no.
You're going to say no?
There's a warrant.
A warrant?
And
Okay, so you have a warrant. Whatever. Whatever. A warrant means you can do anything you want. It doesn't mean you can force me to help you. right? It means you can search my home in any way you want. You still can't force me to unlock my safe for you. You got to call a safecracker. That warrant doesn't give you the right to compel my cooperation. That's not in the Constitution.
You're not compelling the alleged person, you're compelling third party.
That's also not in the Constitution.
We have the All Writs Act.
Huh?
The All Writs Act.
The All Writs Act. That is a thing, and it's very old.
Yeah, 18th century.
So how many times have you heard about really old laws that aren't really used much anymore coming back and being used as leverage because they're still on the books? This is one of those cases where they're citing the All Writs Act from 18 whatever as a basis for forcing the unlocking of this phone. Now, Apple is in a unique position because you and I, when we refuse individually as people, we would go directly to jail for contempt of court when we refuse to unlock this phone. What happens to Apple?
Slap on the wrist.
I slap them. No, nothing. They can't do anything to Apple yet because one, Apple's lawyers are awesome, and two, they went to the public. Public opinion has a lot to do with this. Oh, sure. What's that do to a corporation? Nothing. The obstruction of justice charges do nothing to a corporation. Okay? So there's a lot of issues at stake here. Aside from whether or not antiquated laws should apply to the modern era, which kind of is the whole reason that I assigned the Bill of Rights review, right? The Bill of Rights Amendments, because those are very old, and we're still using them. Did anybody do the Quartering Act, or the no quartering of soldiers? Yeah. I love that one. That's fantastic. So what we have is a case where, does everybody know the actual details of this case? Because it's really muddy. It's a lot muddier than it sounded like when I first presented it to you just now. Because in this case, not only has a court ordered Apple to cooperate, which Apple already was willing to cooperate. They were willing to unlock the phone. And Apple hasn't actually unlocked more than 70 phones in cooperation with law enforcement in the past. That's not widely known. They have a history of cooperating with terrorist investigations and whatnot. Now, always following the letter of the law, having a warrant and all that stuff. What's different about this case, who owns the phone? Anybody?
The individual who purchased it.
No. This phone, I'm asking specifically the San Bernardino shooter's phone. Who owned the phone, or owns? They still technically own the phone. Anybody?
The dead shooter?
No. See, that's one of the problems. It's actually San Bernardino County. It was his work phone.
Oh.
Yeah, that changes things, doesn't it? So what happens? You remember that obstruction of justice charge? Well, let's say you find out one of your employees had their work phone on them when they shot up your office. And you decided that you would immediately try to disable that phone using the enterprise tools available to you. But you don't know the passwords to the accounts that were used. And you try to unlock the phone, and you try to switch the account, you try to go into the iCloud, and you try to do all kinds of stuff that Apple, do you remember that whole Apple iCloud Jennifer Lawrence celebrity gate, also known as the Fappening? You remember that? Yeah, well, it turns out that after that, they got rid of their you can try as many times as you want policy and went to a hard lock. And you have to know the password to the email to get into the system. Not only that, but if you try too many times, it destroys the evidence on the phone. It nukes the phone, right? Everybody's familiar with, you can turn that on your iPhone, that if the wrong password is put in 10 times, it nukes the phone. Did you not know that? Those are big
I don't
iPhones.
have an Apple.
You can do it on your Android too. Yeah, most Androids also have that same feature. It's a self-destruct feature in the
The
case.
default is it'll just lock you out for X amount of time based on, like,
Right.
10 attempts will
But
lock
you-
you out for
but
5
you can
minutes.
turn on the
or
nuclear
whatever,
option.
You can turn
And
on.
if you forget your password.
Good luck.
Okay, so that's what happened is the San Bernardino County office messed with the account on the phone. And so this account is now unlocked and the nuclear option is turned on by default because of their security policies in the county. Okay? Because they're trying to make sure that they don't have an information breach and all that stuff. And so what you really have is a court order ordering Apple to fix the mistake of the owner of the phone who interfered with the process of justice. Apple was perfectly willing to unlock that phone if it hadn't been messed with. But they can't, under the current system, fix the damage that was done to the phone. Now, something else that's neglected to be covered in most of the coverage of this incident is that that phone is probably already trash. That phone, they probably can't get into it. There isn't a back door that's accessible now. All the existing ways into that phone are dead. And so what this case is really about, and that because you've now eliminated the current phone as an option, what this case is really about are all the future phones. How do we handle similar instances in the future? That's what this is about. And so the court order didn't just order Apple to break into this phone. It did include this phone. It ordered Apple to produce software that would allow the FBI to break into the phone. He says you can see where that could be an issue. Online people, I turned off the screen so I can see if you're talking. Does anybody, and you can type too. Does anybody think that that is an issue?
Yes. That's good.
Yes.
Under current federal regulations and police policies, they can do whatever they want.
Well, they can do whatever they want. That's a broad overstatement, and we can look at the Patriot Act in a little bit too. Okay, it's a broad overstatement, but in generally a well accepted that they can do anything they want as long as they have followed the right steps, and sometimes those steps are not real big hurdles. Okay, they are steps, and they are secret steps, like the FISA courts. But that goes beyond this, because this is all playing out in public. Okay, that's one of the things that makes this case different. But the court order has a couple issues, and one, it forces Apple, if they comply with the court order, to produce software that allows the FBI, not Apple, to break into all these future phones. Now, they said there is the proviso that it's only supposed to work with phones that you have in hand, physically, like the software can be designed that it's for physical connection. Whatever. And two, that they could hard code it to only work with that phone and still be in compliance with the court order. Except, does anybody remember a while back there was this technology that Intel made? What was it called? Where they allow for actual hardware level monitoring and remote access of systems so that you could literally boot and load a system remotely through this hardware monitoring port that was done with hard-coded encryption. How long does it take for hard-coded encryption to go out in the clear in the hacker community? That's a trick question, because who knows? But in the case of the last time, when Intel tried it, 6 months. It was less than 6 months, and all of the Intel systems had to be patched to close that hole. It had to go into the BIOS and get rid of the access to the hardware level remote management. Even though it's an incredibly useful tool. It's an incredibly useful tool. But unfortunately, there's no dynamic, you can't change the password, there's no dynamic encryption keys, there's no anything because it's hard-coded into the system so that it works at a raw boot. Same thing here. Even if you hard-code it to this one phone, the hacker community eventually, if you open up that hole, they're going to find it. The other thing that Apple said is the current system doesn't allow for the for the system that was ordered by the court order to happen. So they would literally have to reconstruct iOS with the backdoor capability that has been mandated, and then they would be pushing that new iOS to every phone, which is a huge liability to them, a huge potential violation to us. It's a risk to us and every single company. Hell, even some government agencies have moved to iPhones because of how secure they are. Just like BlackBerry before, some agencies have moved to BlackBerry. The Texas DPS, here, our Department of Public Safety and Department of Homeland Security in that agency use iPhones because of how secure they are. Not because they're fanboys, but because they are secure and manageable. That says something. I know the people who run that office. It says something. And this court order would compromise that system by de facto. Maybe not today, yeah.
Does it also apply? I'm guessing it it has to, you said to all future phones. That's all future new, so like iPhone 8, 9, 10, and all future iOSs, iOS 9, 10, 11.
Right. Right. And that's what would.
And just iPhones? Does it, or
Well,
Apple devices?
Apple only makes iPhones and iPads, and they run the same operating system. So that essentially would be, you know, they make other things, but iOS devices, it's Apple and iPad.
Okay.
Or iPhone and iPad. Right?
So does it say Apple devices though? What if they decide to pull some
No,
loophole and make a new device, rename it, and it be essentially the same thing? But it's technically not an iPhone, and you told us we have to do that for iPhone.
I suppose that's possible. They can just stop the iPhone line, and the next thing you know, there's no backdoor on future Apple products. That is possible. No, the court order is actually quite specific. It refers to this phone and the software. The problem is that the software that is mandated requires those changes, and those changes could be applied to all phones. Right? It would by default if they create it. It doesn't even exist. Tim Cook has stated that it doesn't exist, and they would have to create it. And by creating it, it would expose every iPhone, every Apple user to the same problem, to the potential breach of their information.
So, but if they're changing the iOS for future phones to have this capability, then every person who owns an iPhone currently updates an iOS, so it includes everyone's phones right now. Okay.
Yeah. So there's another issue that hasn't been in the news. That none of the analysis that I've heard, and maybe you have, and that is forced labor. Is forced labor legal in this country?
No.
No. But the court order mandated something that would take literally tens of thousands of man-hours in coding to accomplish. Just thinking about how long it takes to make a full-featured operating system, and how big that team is, and how big the team would have to be to accomplish it in a short time frame. Right? Knowing the software development lifecycle as I do. That's ridiculous. Did the court order specify that any payment would be made for time? No. Did the court order specify that any, what's the word? Starts with an R. Needs a payback. Not remittance is a good word. Reimbursement. Did they state that any reimbursement for equipment of any kind, or lost revenue by reputation of any kind, or any of those things would be made to Apple? No, the court order said no such thing. And so I think that there's even a bigger issue at play here. And this is me talking now. This is Andy's legal analysis, not what the articles you're going to read say. But it's that the court order essentially mandated servitude, forced servitude, without cause for Apple. What do you guys think online? I can see their faces. And I look to my left to talk to you guys because that's where I can see your pictures. But online, guys, what do you think? Huh? Well, the judicial system gets accused of overreach all the time.
But the issue in that kind of order is, they're not resolving a current case. It's saying for future issues.
Well, now let's step back and let's think about the human factor here, right? Public outcry. At a reaction, the vast majority of people said Apple should be unlocking that phone because terrorists. That's what it was, yes.
Yeah.
Absolutely. Until people started to think about it longer and cool down a little, because it's easy to make snap decisions. Look at the Patriot Act, which we're going to look at the Patriot Act later. But look at the Patriot Act. It is easy to make a snap decision such as the Patriot Act in response to an egregious offense. That's what this is potentially. Now, as a judge, within the first week, maybe a judge who's hopefully seeking higher position, higher office in the judicial branch, and you brought this case right after, in the same district as the San Bernardino shooting, and this request is made of you. Do you reject this case? Do you reject the FBI in your first round as the judge? Any of you? Could any of you say, I would reject them out of hand? Probably not, because this is another perfect example of how, even though we have the laws, and the laws should be followed, and it should apply equally, there's a human factor to each step in the law. The jury, made of people. The prosecutor, a person. In this case, the judge, a person. Living in the area, probably having, maybe even knowing some of the people who were there. Not necessarily, but possibly. If they did know people who were there, he should have recused himself from the case. But regardless, it's pretty safe to assume that on that order, if Apple just complied, cool, you're good. But if they don't comply, it's just going to get appealed and go above your head. You made a safe decision. Right? From the legal perspective, the issue has already been decided somewhere else. Let's go back to the screen share. Do you remember how I said that there were multiple, right there, that there were multiple cases in the past where Apple helped? There are also other cases in the past where Apple has been like, whoa, such as this one in New York. Right there. A federal judge in New York ruled for Apple in a similar case over a locked phone belonging to an admitted drug dealer. This guy is a drug dealer. We don't really care for drug dealers. Even if marijuana becomes legal, we still don't like drug dealers. Especially if they sell stuff that's not marijuana. Right? It's easy to demonize drug dealers. It's easy to see them as bad people. And it's easy to say, well, he's just a drug dealer. They don't pay income tax. Maybe they do. Maybe they do. I don't know. They probably don't pay income tax. But there's long been that argument, the free speech argument, right? I don't agree with what you're saying, but I would fight to the death to defend your right to say it. That same thing. He's a drug dealer. Why do we care about him? Well, we care about him because if they can get his phone unlocked, if they can circumvent his privacy, and if his constitutional right to privacy as established in Griswold, later on reaffirmed in this case called Roe v. Wade, I might add, but that's about sexual rights. And it doesn't matter where you fall on that issue, like I said before, because they didn't weigh in on the morality of the issue. They weighed in on the Constitution, on the government's purview to invade your privacy to determine the issue. Right? But here, how much stuff is in your phone?
Now, today.
Now, today.
Everything.
Now, today, everything.
Right.
Hey, online guys, in the text, tell us, how many gigabytes does your, oh.
You're upside down.
I see that now. I'll go back to screen sharing. How many gigabytes of information does your phone hold?
Lot.
A whole lot.
32.
I don't know how to fix the upside downness. I'll try. I'll reset it in a second.
That's okay. I was going to pipe in and say on the case brief, I wrote about the Riley versus California, which had a lot to do with not only having to have a search warrant for the cell phone, but also protecting an individual against self-incrimination. So this would have something to do with if the FBI got that type of software and they were able to crack these things, because of all the personal information we keep on our phones these days, it would almost be self-incriminating.
Not just almost, but absolutely. And I apologize for the upside down. That's going to get weird. But there's another case you need to look at, and I wish I could remember the names, but it's pretty easy. Look for cell phone case Ohio and cell phone case Supreme Court, Huntsville, Texas. Really proud. My lawyer, he's been my lawyer for about 15 years, my lawyer successfully argued a case in front of the Supreme Court, which is like the golden ring, holy grail for a lawyer. Paxton Adams is his name. Just so you know, I think it's A. Paxton Adams because his first name is something normal like Andrew. so he goes by Paxton. But you can look him up. He was the second counsel on the case. But in these cases, the Ohio case, the Texas case, the Riley case in California, in these cases, it's determined that this thing is not just a phone. We've known this for a long time, right? We've known since 2007 when the iPhone was introduced that it was revolutionary because Apple told us, and we gave them all our money. And then Google came out with Android just a few short months later, and that was really cool, man. Because that's my hipster. Or maybe that's the geek and the other one's the hipster, but whatever, it doesn't matter, right? And people started putting their lives in this thing, and this thing called Facebook was blowing up at the time because they finally let everybody in. And it was this perfect storm of innovation that exposed information and exposed everybody's lives as information. And so the difference here is this. This is my wallet. If you could see it closer, you'd see that it's a nerd checker. But this is my wallet, and if I were to be arrested, they could search it. They would go like this, and they would start slowly pulling out all the things. And they would be checking. We lost Raul. He said his phone was going to die. And they would say, all right, he's got an ID, a credit card that is an ID, another credit card, he must be in debt. He got some licenses. Oh, he can carry a gun. And they would inventory this, and they would say he's got some receipts. It looks like he's pretty boring, but he'll be out in the morning. And then the only thing that they'd be allowed to do with this is they'd say, yep, it's got a password. Phone. They can inventory the contents of my wallet. They cannot inventory the contents of my phone without a warrant or my consent as a result of these cases. Now, in Ohio, the case was that they couldn't, and it was drug dealers in Ohio, just so you know. In Ohio, it was ruled that they couldn't just search the phone when they picked somebody up on a warrant. Yeah, incidental to the arrest, or in searching a house. If the phone wasn't noted in the warrant, they couldn't search the phone. Why is that? There's something called a closed bag standard. Remember all these tests we've been talking about, like the chilling effect is one of the tests for the First Amendment? It's a closed bag standard. And in Ohio, they imposed the closed bag standard to the cell phone. And the closed bag standard is that if you are, say, arresting somebody because you pulled them over on the side of the road, you're arresting somebody, you're going to search the car, right? You can't actually open the closed bag. It's a closed container of private property, and you have to have a warrant to open the bag, even incidental to an arrest, unless the arrest has something to do with the bag. But getting pulled over for a traffic warrant, you forgot to pay your speeding ticket. They can't search it. They inventory it. Bag. That's what it says on the inventory. And they tape it up, put it in a bag, and they store it. That's kind of dangerous. It could be a bomb. Seriously. It could easily be a bomb. But what this is it gives you access. The reason they can do this is because I can't store that much personal information in this wallet. I can't store that much private information in this wallet. Now, I don't want you, writing down my credit card numbers and stuff.
They already have driver's license.
They already have my date of birth, my address, my driver's license number. They can already commit all the fraud they want to commit in terms of identity theft potential, right? But what they can't do, I should go ahead and put these rent checks in that wallet. But what they can't do is unlock my phone or force me to unlock my phone. The case in Huntsville, what happened is, for a while there, it was the standing procedure of the Huntsville Police Department. Every time somebody was arrested, they would take their phone and dump it. Now, I can tell you why they do this, because sometimes it catches people that they've been looking for. Does anybody remember a few years back there was a bomb threat, a fairly credible bomb threat, say I think it was in 2010 or 2011? 2011. a fairly credible bomb threat to Texas A&M University. Does anybody remember hearing that in the news? You were there at the
I think I
time.
remember that.
So let me tell you that story real quick. They received bomb threats. They were very specific, which is one of the things we look for in credibility. They had a lot of trigger words, right? It ended up not being real, thank goodness. But they really, really, really wanted to find this person. They called me, they called the RCFL, they called all kinds of other people, that's the only reason I know about it, to say, all right, what are your ideas? How do we catch this person? This person was caught because of that process. Their department also scanned every phone that came in. And the perpetrator was arrested on an unrelated charge, and those emails popped up when they searched the phone, non-related to that arrest. Now, under the current standing, they would not be able to do that. That person would not have been caught. So there's a plus and a minus. But because of Ohio, Texas, and Riley in California, and I can't remember Ohio and Texas, I can tell you, like I said, my attorney in Texas, and I don't remember the case in Ohio. But they store so much information, so much private information that previously takes a warrant to get a hold of. For example, all your financial records. If you've ever done your taxes and you've received confirmation in your email, your entire tax history is now accessible through your email. And if you don't have a password set up separately to your email inside your phone, does anybody have, in class, does anybody have a separate password on their email? Can you even do that? It's just on the device, right? No. You just click on the application once you've unlocked the device. And it opens with the pre-stored credentials that you've already given it. Your pre-stored credentials are in there somewhere too, if somebody can figure out how to extract them. Most of the forensic software doesn't defaultly extract those credentials. But it could happen. Your entire life is accessible, your entire private life is accessible, and your entire network is accessible. Every phone call you've made, every person you've talked to, etc. Now, I don't know why that made me jump to this, but toll tag records. There's a rise in two things in divorces right now. One, Facebook. Facebook is cited in like 1 out of every 3 divorce proceedings in the United States right now. And 2, toll tag records. Toll roads have become so prevalent, and because it used to be cash, it was anonymous. Driving through was anonymous. We weren't tracking people. But now, because of convenience and high speed, we have toll tags. And those toll tags, they beep, I know who you are, automatic license plate camera, I know who you are. And with a subpoena, they turn them over because it's a public place, a public road. You don't have an expectation of privacy necessarily. And so they turn them over, and lots of divorce cases are citing toll tag records as you weren't where you told me you were.
Wow.
Yeah.
Actually, though, a lot of highways are opening now without cash tolls. The Grand Parkway, Highway 99, they just opened their new segment, and they don't take cash at all. That entire long strip is all easy
And why
tag.
would they? It's such a gold mine, not just in terms of money, but in terms of information. It's a gold mine. Just wait until they start calculating your average speed over distance based on what time your pictures were taken. Seriously.
Oops, you speeded. Automatic speeding
Yeah,
ticket.
you got a ticket.
Yeah. Because they can measure to the millimeter how far those tolls are from each other. They can give you a tolerance because maybe you were in one lane and then the other lane, and maybe you changed lanes many times, which extends your distance slightly, right? Google Maps is probably close enough. You're not going to extend your distance by a mile changing lanes. If you are, they can look for the vomit. But it's that data. And it's that data that made your phone not accessible because of these court cases. They recognize the importance of that data. And the Apple case wants to go around those cases, essentially, and provide law enforcement those rules to get back in. It's on the other side of those decisions. So we'll see who's right, because it was a federal court in the 9th District The 9th District is California. And a federal court in the 1st District, the Northeast, might have been the 2nd District. That, I don't remember which district New York was in. I want to check that. And that means that when you have opposing decisions from 2 separate federal districts, if the district court, the district appeals court in those districts rule opposite of each other, it's going to the Supreme Court, no matter what. These cases are going to go to the Supreme Court, in my opinion, which is why they're fun to talk about right now. Last year, net neutrality was just boiling over when we started class, and so it was a lot of fun. This year, this is amazing. This is why we're opening with privacy, right?
Yeah, the 2nd District.
2nd District? Okay. So yeah, 1st District is Washington, D.C. in that area, I think.
So, all right, I'm kind of new to the forensic thing.
Okay.
So, is current forensic technology not able to open an iPhone?
No. The older generations, there are techniques you can use to get in. The brand newest, no. Same thing though with the phone I'm about to get next week.
Yeah.
Every time they come out with a new phone, it's a new, sorry, we can't get that. You give it 3 years, that phone will be like an eggshell. But right now, no.
It's annoying if you're the person trying to get in.
She's working as a digital forensics intern at the police department right now, so she knows.
The iPhone, and most people have iPhones at this point, so you get them like daily, and the only way you can get in all the other, pretty much all the other phones, it'll go around, and it may not give you the password, but it can image the phone without unlocking it. But iPhones, it won't give you the password. It won't even image it unless you unlock the phone.
It has to be unlocked to get the image.
Yeah.
Because they disabled physical imaging of the system as part of the design.
So you have to do the whole trust the computer or whatever and stuff. So you either have to have a stupid criminal who used their birthday, or you have to know the password.
Because you're allowed to guess. You gotta stop.
Oops,
before you-
I accidentally typed in the right number.
Yeah, you gotta stop before you nuke their phone, though.
Yeah.
Because if you nuke their phone, you're liable for damages.
Usually you'll try like one.
Yeah,
but-
you can give it a couple tries.
If it's not their birthday, they probably weren't stupid enough. Birthday of 1, 2, 3, 4.
Or 6666. And that's because most people are right-handed. And 6 is right there where the thumb is. 6, 6, 6, 6, 6, 6. And all they have to do on an iPhone, because an iPhone doesn't require you to hit enter. You just go, you hit it until it turns on. And it turns on.
So there's not a password on the phone.
Huh?
I mean, Apple requires a password. Android does not.
Right.
Android is free game.
Under the current rules, it's still a closed bag because they've gone the other direction. So what we do now is we get consent to search forms in almost all cases, and it's amazing how many people are stupid enough to get permission.
Because they think they weren't stupid enough to put all the evidence needed on their phone.
Yes, because they don't understand what information is contained on that phone, what's in that closed bag.
And they think if you hit the delete button, then it's gone forever.
Yes. So hooray for stupid criminals who are willing to sign consent forms. My favorite story is Scott and I did a case. Scott is her boss. Scott and I did a case about 5 years ago now. Might have been 4 or 5 years ago. And the young man was accused of rape. And he was willing to sign anything he had to get himself out of a rape charge. And so he consented to search of everything. Search anything you want. I didn't do it. If you're a drug dealer, you should let the courts handle it. You should say, I didn't do it, and you have to prove it. Because,
Here's my lawyer.
or at least you should have your lawyer, you should have your lawyer sign a very narrow consent to search form. But this guy signed a we search anything you want form, and what we found was very consensual sex, and lots 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 of drugs. Like bales of drugs being used as coffee tables and stuff in his apartment. So I was able to describe the apartment from the pictures, get a warrant, and he never set a foot on free dirt again. So that was my favorite.
That's actually
case.
probably like 2 or 3 times, even in the just past like month or so I've been working there. There's been so many phones. There's been several phones that come in for one thing, or it's like witnesses in a case or something where people are like, sure, look, and they're like, all of a sudden they've committed a crime that nobody even knew about until they signed over their phone.
Right.
Because they just.
Because they're so focused on that one thing that
Yeah.
they forget that they're a bad person. Because they were innocent that time. So if you're not a good person, don't consent to have your phone searched. And if you are a good person, don't consent to have your phone searched. Never consent to search. If they had anything on you, they wouldn't need your permission. Just saying. Okay? As the guy teaching the law class, if they had anything on you, they wouldn't need your permission. And if you meet Scott, don't tell him I said that. Okay. Phones are not the only place where this issue hits the road. Where else is privacy a big concern right now? Because we're doing privacy, remember? And right now we're mostly exploring the issues. We've talked about a couple cases, and we haven't referenced any real laws yet. We're about to. Yeah, I hear Scott. Oh, you're just testing? That's makes me sad. Where else does privacy matter online? In cyber context, in whatever. What's your password? Gmail. What's your password? There you go. That's the right answer. Every single account you have is private. Or is it?
No.
So would Gmail hand over your information?
Technically,
Were they
you
property?
signed the terms and conditions. It's technically their property.
But
For the
not
property.
Gmail.
Okay.
Gmail is not their property. Not in their terms and conditions. But there is a classic case study, a juxtaposition, if you will, of 2 instances. Facebook and their nemesis, the Twitterati. Facebook says they own everything. Twitter says they own nothing. What are you going to say?
The courts decided that Facebook is generally a public medium.
The courts didn't really have to decide that because it's in the terms of service. That it is a public forum, it is a public medium, but you do have, Congress has even called Zuckerberg to the carpet at Congress a couple times in the House of Representatives to testify as to why the privacy settings were mismanaged in Facebook. I think he's been to Congress 5 times over privacy concerns. But that's privacy.
But isn't it like when they update Facebook or they change their privacy, saying all accounts get set to default, or they used to have something in it like that or something? I
And
don't know.
if
if
they screwed up and set the default at the no privacy, then everybody's open. So they've done this a few times. They have exposed everybody's profile to public. They have exposed everybody's relationship histories to public. They have exposed everybody's message histories to public. And one time they even exposed deleted profiles to public. And when I say deleted, I mean deleted, in quotation marks. Air quotes if you can't see it. Their deleted profiles, not so deleted, it turns out, in the past. These days, they claim that it goes away after 90 days, but good luck proving that. Right? Seriously. So Facebook says they own all your information, and you have the right to use their service, and you paid for it with your information. Information being their currency. Twitter says you own all your ideas, all your information, and they own nothing, and they make their money through advertising and stuff. You didn't pay for it with your information. The advertisers paid for it. Okay? Even though they run on the exact same model economically, philosophically, that's a huge difference. So Facebook has gone through a number of cycles in terms of how they will share information with law enforcement. Okay? Way, way back when, they started out and they're like, we have nothing to hide. Nobody has anything to hide. It's open. There were no privacy controls. controls. And then privacy controls came along, and people could lock down their profiles. You couldn't see them. And so they started out providing full profiles and 100% information on any person requested with law enforcement letterhead. Not a subpoena, not a warrant, not even a verified individual from the police department. If you emailed them a letter in PDF format on law enforcement letterhead requesting access to a given user's profile, they would send it to you in its entirety. Well, guess how well that worked out? That didn't work out so well. Sorry. I mean, it worked out really well for a couple people who got information they shouldn't have had, because there was no validation, right? All they said was, all right, you have police department letterhead. How hard is it to get police department letterhead?
There's a keyboard and a Google search bar between you. I'm sure you could pretty much search.
I've never looked this up. Let's find out.
I can't say I have, but I wouldn't be shocked if you could just like Google NYPD letterhead and all of a sudden.
NYPD
An official letter from NYPD.
images. And we're using Yahoo, by the way. Look at that.
Just gotta blank out the bottom part.
There you go. I expected that to be cooler. It's the same font as like the New Yorker. It's the same font. So what we have here is we have a system that didn't have any procedure. They thought it was a safeguard, but it's literally that easy for me to generate police letterhead if I want to commit fraud, right? And also, am I really committing fraud? I'm impersonating a police officer, so I guess I'm doing it in that way, and I could be charged by the New York Police Department if they wanted to get me, right? But they weren't verifying that you were coming from a legitimate police account. They weren't verifying any of those things. So they got wise to that. And they said that they would respond to any subpoena, any warrant, and they always have. Facebook has been remarkably cooperative with law enforcement efforts over the years. So they comply with all these things. Then they came up with a liaison system where each department could designate one or a few, depending on the size of the department, officers to function as the Facebook liaison. If you need information from us, we will comply, but it has to be through this person who has been trained and who we recognize and has been validated. We have verified that you are a real police officer with a real police department, and we will only send the information directly to you for your cases. That's actually not a bad system. And the current system still applies to all subpoenas, all warrants, and they will use a liaison officer, though the program hasn't been as popular as you would think it was. Okay? But they also cooperate on the back end. Have you guys heard about the DEA program with Facebook? So, have you ever looked at the search engines where you can search by image?
Yes.
Yeah, it's cool, right? I mean, we're computer people, we've done that. Let's see if it resets. Nope. Anyway, these image resets, just see if you can put that. These image searches can be used privately. So Facebook is largely built on images more than anything else, right? It's the pictures that make Facebook. And so the pictures that are uploaded are of various things. They're of people, places, things, and illegal activities, specifically drugs. And so Facebook wants to be a clean family medium. I mean, drunk sorority girls aside, and puking sorority boys, and whatever other pictures people go out and look for, or that maybe used to be a thing, now it's grandkids. Oh, we're right set up. All right. So they instituted a program with the DEA. Sorry, I'm back on track now. They instituted a program with the DEA to scan all the images and look for illicit activity based on criteria provided to them by this law enforcement agency with whom they are participating. And they are providing the profiles that pop to the DEA directly for investigation as leads. Just wait till that goes to court. It's going to go to court. So what are the actual laws regarding our activity and our privacy online?
There aren't any.
There aren't any. There are a
There
couple.
are a few, but not.
There's the All Writs Act
1800.
of 1800 something. Online guys, do you guys know of any laws that are actual computer laws that help govern privacy or security of systems? One passed in December 2015. It was hidden in a budget bill. We'll get to that. But first I want to go back to 1986. The Computer Fraud and Abuse Act of 1986. The Computer Fraud and Abuse Act of 1986, computers were starting to become a big deal. The internet was a fledgling thing, but it wasn't the web. Remember that the internet and the World Wide Web are separate things. That's what I do. I didn't run through my timeline of the internet. We'll do that later. Those are separate things, okay? The internet is an infrastructure. The web is this delivery system that we're using for class right now, HTML-based, etc., right? Once you connected all these systems, it was a natural fit for fraud. Because committing fraud in person, right, watching the ink on a money order, if you want to look at committing fraud in person, go watch the movie Catch Me If You Can. Great movie. Mr. Abagnale is the main character, and Mr. Abagnale is one of the most prolific fraudsters of all time. So prolific that he got caught. And he got caught, and then the FBI said, hey man, you're good. Teach us how to catch people. And so he then made a career after his career of crime of teaching and helping the FBI catch fraudsters. It's cool. I met the man. His wife is a bear cat, so eat 'em up cats. I met the man a few years ago. Amazing to talk to. He's a con man, yeah. He still has the personality, and he's a con man. Great guy to talk to. Maybe that's why Bill Clinton was so fun to talk to. It really might be. I never thought about that. So, I also met Bill Clinton a few years ago. But the Abagnale, well, that movie will teach you all you need to know about committing fraud in person. But committing fraud in person is dangerous because people can see you. Right? Committing crime, committing robbery, committing murder. Face-to-face, it's a messy affair. Online, it's just a screen. So the Computer Fraud and Abuse Act was a forward-looking piece of legislation, that started to attempted to address these problems within the scope of understanding that they had of connected systems in 1986. It made it a crime to access any system without authorization. Right? Anybody seen the movie War Games? Matthew Broderick? Fantastic movie. Go watch that one. Because it's based in the 80s. Around computers and connected systems. And the Computer Fraud and Abuse Act of 1986 is basically the last legislation we got, firm legislation that was directly aimed at computer crime. Because most of the other legislation that we rely on is, now, the DMCA talks about it, right? We're going to get to the DMCA next. But the rest of them aren't about accessing systems. They're not about securing systems. They're not about treating the infrastructure as a highway and trespassing and all these other traditional crimes that are now digital. And so it might be time for an update. That law has been also used because how do you investigate crimes of this sort? That law and laws around that time, you think encryption is a new battle? No. So it turns out that the NSA, those guys, the NSA asked for a backdoor to encryption and has been fighting for a backdoor to encryption for decades. And it goes back and forth, back and forth. Do you have a right to strong encryption? So, in computer science, Josh, what's the highest math class you've ever had?
Cal 2.
That's the highest math class you had? You cheated. What's the highest math class you've had, Megan?
I mean, I've had
Just what's the worst, like atrocious, like blows people's minds apart?
elementary analysis.
Elementary analysis. Okay, I don't even know what that is, which means it's the right kind of math. Okay? In computer science, it's not uncommon to run into people who have had more than the average amount of math. Calculus 2 is already way over the average amount of math for the average person in the United States. Okay? In theory, you could come up with some sort of strong, you guys could come up with some sort of strong algorithm for encrypting your work on your own, based on nothing but math. Can you illegalize math?
I'm out of a degree, if so.
She's out of a degree or so. It's a universal truth. Can you illegalize math? No? I mean, that wasn't very confident. Yes or no?
Ban on all CIA.
Put a ban on all TI-83s. There you go. I don't think you have to worry about TI-83s crunching prime numbers to 400 digits or whatever, right? But in general, you can't legalize math. And so talking about forcing companies to go backdoors into their encryption is a back and forth discussion because it's like forcing people to cripple math. It's like trying to make 2 + 2 = 5. Right? How do I sneak you in the back door to see the solution? Well, I just tell you it worked. It's full, or it's secure. But if I build a back door in, everybody's going to be able to find it because math is universal truth. That's why Intel couldn't hide their keys. And so this is not a new battle. Andrew Comey, is it Andrew Comey? Comey. All I know is that his name is Comey. Let me pull his name up real quick. I'm not going to do the share screen, so I'll go bouncing upside down again. See how I had all these things ready for you? Those are failed. CISA, cybersecurity. There we go. James Comey, not Andrew. Andrew Cuomo. James Comey. James Comey, FBI director currently, and his predecessor, are asking for backdoor encryption. Again, same story, different agency. Well, yes.
Fight the terrorists.
You remember at the
Good thing.
beginning? Because terrorists.
Like Call of Duty.
It's because terrorists. So, what they're asking for is they're asking for a law to force it. It's not like they're working on private partnerships with companies on a secret backdoor deal, which, while it sounds shady, is probably the more ethically correct route to go in terms of actually protecting average citizens' privacy. That's kind of twisted in and of itself. Because if the only way you have to protect the privacy of your citizens is to make shady backdoor deals with companies to ensure that you have the capabilities you need without advertising those capabilities, I'll go ahead and screen share. Josh figured out how to flip it.
Well,
He looks very grumpy there.
He does.
He looks, I think he also looks kind of chunky there, and he's neither in general. We've seen him in other places. He's actually a fairly jovial person in pretty good shape. But that's a horrible picture that really works for the story.
I'm an evil FBI director and
Exactly.
I know everything about it.
shady backdoor deal. I don't even know about it.
Well, it's not. They're trying to go the transparent route and tell people that they're forcing it to happen. And they're trying to actually make it a law to make it happen because that law doesn't exist. Which is what I'm getting at, is that the majority of these laws that we think should exist or that we wish would not exist don't exist. Because of the major laws that have actually passed, most of them are aimed at pornography and piracy. Because in other countries, what does Europe care about to regulate? No, I mean online. What does Europe want to regulate online? Online guys, feel free to type in your answer. Josh, you're up. Feel free to type in your answer in the text box. What does Europe, in your opinion, want to regulate online?
Right now.
Isn't that hacking tools? Aren't they big on that?
Hacking tools? No, not really. Censorship. It's censorship. What kind?
Anti-migrant.
Anti-migrant? Nah. No, they're okay with anti-migrant stuff right now. Yeah, Europe is very okay with as a whole, is very okay with anti-migrant stuff right now. Nobody online wants to type in or chime in? I want to know, what does Europe censor? Because that's what it comes down to, right? What are they trying to control? What are their laws built around? What laws do they apply to the internet for control? It's hate speech. Their censorship is built around hate speech. It's built around cyberbullying, threatening speech, and Nazis. They don't want you using the word Nazi in Europe for some reason. Seriously, that's what they want to control. They want to control dissident speech around Nazism, fascism, etc. Okay? They would like to control that discussion outright and or just ban it so that didn't happen. Or not that it didn't happen, but geez, if we talk about it, it might come back. Or if you don't talk about it, maybe it'll come back. I don't know. That's what they want to ban. China, Iran, which frequently, I hate to break it to people, don't actually have that much in common. China, Iran, North Korea has more in common with China and Iran, but in different ways than each other. What are these countries? What do they seek to control in their online laws? And there are many other countries that try to do this.
Their image.
Politics. Their image, their reputation, and their politics. Because their politics are built on image and reputation. Right? The image and reputation of the Shah. But not the Shah, the Shah is who was ousted. What's the other guy called? Khomeini is the Ayatollah. The image and reputation of the Ayatollah. The image and reputation of the Communist Party in China. The image and reputation of fearless leader Kim Jong-un. It's funny that we all laugh, but he's the megalomaniac trying to build nukes in his basement.
It's crazy, but it's just too crazy.
It is very crazy. Okay? And he uses his cyber army, and he has a cyber army to attack Sony. They did make a movie, and in that movie they kill him. And so, I mean, the United States wouldn't be too happy about an assassination movie.
That's why I laugh every time I think about him now. I watch The Interview. Can I not laugh?
Yeah. They picked a guy who's in much better shape to play him. That's what I kept noticing. I was like, he's supposed to be shorter and fatter. Says this guy. But that's okay. They seek to control politics. Other places seek to control hate speech and expression. We seek to control decency. Because for all of our freedom, and for all of our talk, and all of our opinions, we are prudes. That's not a bad thing, necessarily. It just is. India is actually on the prude list as well. They are seeking to control pornography in their internet controls, and are just illegalizing it if they catch people doing it, then they'll throw them in jail. But we seek to control pornography. We seek to control indecency and obscenity. We're very focused on protecting children. That's what we seek to do. Ideologically, there's nothing wrong with any of these things. At face value, there's nothing wrong with trying to make sure that your politics stay even according to your perspective of even. Right? There's not. At face value, there's nothing wrong with trying to make sure you don't repeat historical mistakes. And at face value, there's nothing wrong with trying to protect the children. But the execution can be a problem. So in this country, the laws that we have actually managed to pass since 1986 are solely strictly focused on intellectual property because money, and decency or obscenity because children. Huh? The children is the only one we actually agree on. The children is the only one we actually agree on. But we still can't agree on how to do it because it turns out that all those children laws, those are the ones that got thrown out. And the money law, that one stayed. So, the children laws. The CDA, the CIPA, and COPA. In no particular order, because if I recall, they all got thrown out. And that is the CDA, the COPA, and the CIPA. Children's Decency Act, Children's Online Protection Act, and Children's Internet Protection Act. Okay? These are all from the Bill Clinton era, but there's one more from that same era that still exists. What is it, Josh? This is your thing. This is what you asked for. In the forums, today is your day. What? DMCA. Everybody but Josh answered. It's the DMCA, the Digital Millennium Copyright Act, passed in 1995 and brought into law in 1996. All of these things are centered around pornography and software piracy. Now, the DMCA has also been used for all kinds of things, such as counterfeit goods sales, online sales of counterfeit goods. So I'm going to tell you a story now about how these things are implemented, and feel free to look these up. But the DMCA, who handles DMCA enforcement from a law enforcement federal perspective? Anybody know? Online guys, who handles the DMCA?
The FBI?
Nope. Try again.
Three-letter agency.
Not the NSA either, but good guess. It is a three-letter agency. They're all three-letter agencies. all the law enforcement.
CIA, DEA.
It's the DHS, Department of Homeland Security.
It's a big umbrella.
The big umbrella. They're in charge of it, okay? And it's actually Customs, which was brought in, okay? Because protecting counterfeit goods and the integrity of business and blah, 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 blah is built in, okay? So they enforce it. And under the DMCA, they have the power to seize domains. Did you know that? Yeah, like website domains. So look this case up. It's great. And this is not a court case. This is an incident. Picture this. There's this place. Some of them are called Tripod. Some of them are called GeoCities. Some of them are called, what is that? What is the newest one? Space Maker? Space? The newest website creation.
Squarespace.
Squarespace. Picture that. Well, before the DHS became so knowledgeable about subdomains and about shared web spaces and about all these other things, they were just reacting to any letter and or evidence. And what happened is Little Johnny has a website. And he built a website. Little Johnny is completely legitimate. Little Johnny is not the punchline. Got you there if you know Little Johnny jokes. Little Johnny is not the punchline this time because all he did was make a website to show to his grandma. And he put some pictures on his website, and he puts it up, and he calls Grandma. He says, Grandma, go check out my website. He's very proud. She says, okay, Little Johnny, I'll do it tomorrow. And Grandma goes to check out the website tomorrow when she gets on her computer because Grandma's on a schedule for doing this computer thing. That's new stuff. And she gets on there, and there's this large Department of Homeland Security, National Security seal on the screen when she goes to Little Johnny's website. She's like, oh, that's cute, except for the disclaimer on the other side that says, this domain has been seized for either, they're not even specific, this domain has been seized for either counterfeit goods sales or child pornography distribution.
So Little Johnny's either selling counterfeit goods
So
or
Little Johnny's
child
either got a side product thing going on, or posting naked pictures of his butt for his grandma. Neither of those things happened. Little Johnny is a completely innocent bystander in this. It was a legitimate website and whatnot. But it turns out that the DHS took down over 80,000 websites because one of the shared sites in the domain had illegal content. But there was no due process for any of them. It was just taken down. No notice, no nothing. Look that up. That's very interesting.
So you're not talking about like when people buy their own domains. You're talking about, oh, build your website for free, and now my website's mywebsite.squarespace.com.
Right.
Okay.
For this case, that's what I'm talking about. But for, because it's also, if you have your own website.
Yeah, you can, like
they,
Sam Houston has mail.shsu, library.shsu.
They can seize those domains if somebody if they can show evidence. They have a higher burden of proof. Right? They can seize those domains. If somebody starts sharing out child porn from the shsu.edu main site, they will seize that domain until it's remediated.
What if one of us does it on, so, because St. Houston, we all have, whether you actually develop it or not, we all have our personal pages, our / username. What if I went on there?
Since our
and posted-
domain is attached to a Class B web space, they would send the ISP notice, which is the security officer for campus. The security officer for campus would identify the student, and that student would probably be US.
So don't do it.
So don't do it. We also have automated scanning filters and stuff like that. The previous security officer, his graduate project, because he's a graduate of ours, his graduate project was an automated child porn filter. So it already exists. And he would know before the FBI or the Department of Homeland Security ever found it. It would already have reported. But in other less proactive places, and before the age of understanding of internet architecture at the federal law enforcement level, they would seize large portions of domains based on the DMCA, right? But I want to talk about real quick those pornography laws, the CDA, CIPA, and COPA, okay? The Clinton administration desperately, desperately, desperately wanted protecting children to be part of its legacy, okay? And it's not just Bill Clinton himself. There were lots of people who wanted this to happen. But none of the laws that they passed were were constitutional. They were all thrown out for various reasons because of the tests. And I'm going to have you guys read those later. They're very interesting. But they were all thrown out because the internet is notoriously hard to regulate. The DMCA has stood up against many, many challenges, very surprisingly. We've had the CAN-SPAM Act, is another one that's tried to regulate. CAN-SPAM. I forget what the CAN stands for because it means that they wanted to throw it in the trash can, right? It was the CAN-SPAM Act, but if I recall, it was thrown out because spam is, many forms of spam are protected legal speech, and it has since been adopted that they have to provide a way out, right? You have to be able to opt out of spam and stuff like that. And that's an evolving area. But no effective legislation has been passed to protect against hacking and whatnot. We're relying on very old statutes. Some states have gotten ahead of the curve. But this isn't generally about state law, except that you need to understand that in the absence of federal law, state law prevails where applicable. Right? So I'm going to send out all the links that I pulled up here. And one of the links I pulled up, sharing, I'm going to go back and have your flip button ready. One of the links I pulled up for you guys that I'll send out after class is this list of cybercrime statutes by state. Texas is on there. Section 33, Lot 2. Computer crimes, classified under offenses against property in the Texas Penal Code. That's interesting. Now, we could go into a long-winded dissertation-like discussion of the basis for property under law. But let's just assume that there is a basis for property and the protection thereof under U.S. law, unless you guys really want a long-winded dissertation on the philosophical basis for property. Huh? I've heard it. Yeah, I hope you guys have. If nobody has, we'll schedule an appointment. Okay? But basically, it's that you do have a right to property. Very few people in the world actually believe that there is no right to property at all. There are differing opinions on how much property and what type of property you have a right to own, but not whether or not you have a prima facie right to property. So Title VII, an offense against property, Chapter 33, computer crimes. This is how the state of Texas feels about this issue, right here. Huh? It's really not all that much. You see how big that slider bar is? Not very big. But it does define things like critical infrastructure, refineries, stuff like that. Breaches of computer security, etc. Online solicitation of a minor, protect those children. Defense. It is an affirmative defense prosecution that the actor was an officer, employee, or agent of a communication, common carrier, or electric utility and committed the prescribed act or acts in the course of employment while engaged in an activity that is necessary incident, that's poor English, necessary incident to the rendition of service to the protection of the rights or property of the communications common carrier or electric facilities. Wouldn't you have thought that there would have been, you know, an affirmative defense for law enforcement, posing as, you know, soliciting minors or something, or joining a community of child predators? There's not. It's probably covered under undercover work statutes elsewhere and being applied. Prosecutorial discretion, absolutely. So, just so you know, you should take a look at this, because for those of you in Texas, and if you're not in Texas, feel free to reference your state. I know that Daniel, who is not here tonight, Daniel is in Florida, so if you want to check out Florida, and they have more than one section. I'm going to send all of these out for you. What are some of the biggest issues in your mind around enforcement or around crafting laws? Remember, I want you to be thinking about crafting laws. What are the issues that need to be taken into account in terms of crafting online regulations and privacy? Do we need more laws? Can we adequately apply them? That's a good question. Do we need more laws? Can we adequately apply the laws on the books to the cyber world? Online guys, what do you think? Are the current laws sufficient if we can find out how to apply them?
I believe so.
Okay, anybody else? Not even close. See? Ask two people, get two different answers. That's how this subject works. Because a lot of people, and I reckon that I'm going to see that when you guys grade each other's Bill of Rights evaluations. I think you're going to see a lot of perspective. I think you're going to see that half the class, probably 50% of the class, feels differently than you, regardless of which side you're on. Right? Because there's going to be a lot of people who, they might even write in their paper, man, this was difficult to find. You shouldn't do that, but some of you will. It was difficult to pick. It was difficult to figure out how to apply these very old things to the cyber world. Hopefully that wasn't the case. Hopefully we were able to do that, right? Now the next question is, should we have to? Not can we, but should we have to apply these old laws, or is it right to make new laws? I already know Mark says it's right. Jennifer, should we make new laws?
I don't know. They already were trying to create the Cybersecurity Bill of Rights, which was thrown out because I think we have so many laws on the books. I think that we just need to take a better look at how to apply those to our digital world.
Even the laws they wrote, they were probably outdated by the time they got them signed.
Oh, for the cyber laws?
Yeah,
Yeah.
like the internet and cyber.
There is a reason.
That.
There's a reason that there hasn't been a substantive security legislation, cybersecurity legislation, directly applicable to cybersecurity since 1986. Until, what did I say at the beginning of class? That one passed when?
Snuck it in
December 2015.
December 2015. It's a great time to be in cyber law. December 2015, they brought up CISA. Anybody know what CISA is? And I know being the Roman Emperor.
Is it going to be like SIPA, another let's rename it?
No, it's not.
Okay.
The Cybersecurity Information Sharing Act. Man, this thing's big.
Right, that's when all law enforcement agencies are supposed to share their information.
Yep. That's one of them. It started off as a presidential directive. It started off as a presidential order directing all federal agencies, because the president actually has control over federal agencies, directing all federal agencies to start to work to share information together and to effectively start sharing information soon. I attended a cybersecurity summit last year around this time of year that was built around that announcement. And we got to watch the president sign it. I wasn't at the White House when he signed it. He was in California, and it was simulcast to the Federal Reserve branches around the country. And invited persons got to go to the Federal Reserve and watch it. It was cool. And we had discussions in the rooms, right? But we didn't get to interact with the president. He But the Secret Service, the FBI, the Department of Homeland Security, and a bunch of us researcher types, we all have to put our heads together and say, well, how are you going to do that? That was cool, because there's no legal framework until right here. Now, this was hotly contested. They tried to push it through multiple times on its own. Guess what? It didn't happen. It didn't even get close to going through on its own, but it slipped through by being appended to a budget bill that almost certainly had to pass, which is also how it became legal to carry your handgun in national parks. I don't know if you know that story, but the provision that made it legal for concealed license holders to carry their handguns in national parks, in all national parks, went through as a result of a budget bill. It was amended because they needed to pass. So somebody was like, fine, here, I don't like that bill, but have my piece. Huh? Like a Department of Defense bill. So, this law is aimed at federal law enforcement and local law enforcement and providing a pipeline, but it's also aimed at including businesses. This is where the hiccup is, because it's supposed to mandate and almost fiat, because there's not a whole lot of specificity that can be provided on how to do it, only what should be done. Does that make sense? And they want companies to openly share with the FBI, and it gives the FBI permission to openly share with companies, which is something that in the past never would have happened. It's not a bad idea at face value, just like lots of things. So, who gets attacked the most? Cyber attacked the most in the country? Businesses.
There's money.
So who has the, well, it's not just money, it's connectivity, infrastructure, personnel, intellectual property, all kinds of stuff other than just money, because it goes to the motivation of the attacker.
Massive firewall.
What's that?
They can't afford the massive security infrastructure.
Well, I don't know. Marathon Oil, Exxon, Bank of America, they have massive security infrastructures. Massive, massive security infrastructures. In fact, a little known tidbit of trivial fact, Target has the best digital forensics department in the world. Not the best management in their cybersecurity division necessarily. Certainly not a great data loss prevention program.
There's a reason they need that digital security.
But their incident response and digital forensics team, they produced a pretty good report really fast. And that's because they actually steal a lot of these little law enforcement people. But if you can leverage the capabilities, and more importantly, if you can leverage the intelligence, not information, intelligence. Do you guys understand the difference between information and intelligence?
Yes.
Okay, awesome. You sounded very, don't go into that.
Well, it's only because, I mean, part of this is already working. I mean, the FBI has been working with a lot of businesses, banking and industry. I mean, for example, on ATM skimmers. The FBI has been working with a lot of banks on trying to reduce the skimming incidents. So they have been identifying the gangs that are out there and cracking down so that they can catch them quicker. So they've been sharing intelligence, not just information, but the intel behind who's doing it, how they're operating, so the banks can be better prepared to catch it quicker.
Yep. Yeah, because intelligence is curated and actionable, and information is just the water hose. It doesn't actually do anything. Water is just water until you put it through a fire hose and aim it at fire. And that program actually started in about 2006, the one she's talking about with the FBI and the banks. And it was piloted at some banks, and then skimmers became cheap and widely available, and the technical know-how. That's a great program and a great example. I'm going to review that next year. But that program they're trying to extend that program into other areas. They're trying to extend that into normal business, and they're trying to get the businesses like Target, like Marathon, Exxon, and any other large companies, especially those companies tied to critical infrastructure, to share their intelligence, because they all have internal business intelligence and security intelligence departments. They're all generating information And they're all aggregating information and generating intelligence 24/7, all the time. They have armies of analysts. And while 42,000 people work at the FBI, 42,000 people work at each one of those companies. And so that the goal of CISA is admirable and good, and we'll see if it works out, right? Because it's still too early to know. We don't know if making that program law is going to be an effective solution or not. But we sure are going to talk about it. All right. How are we doing? What time is it?
7:30.
7:30. What have we covered about privacy? Let's move on from privacy. You guys need a break yet? It's been an hour and a half. I always forget. No? Yes?
No.
Yes, you need a break? I have to give it the option for a break. All right. 5 minutes?
Yeah.
5-minute break, and then we're going to move into piracy and information theft, intellectual property theft, and we'll call it quits. Whew. Jennifer, do you work in banking?
I did until yesterday.
Oh no, did you quit? I hope.
No, that was part of my email to you. I was, aside from my old mother falling, I switched jobs. I'm now in the oil industry.
Oh, wow. You're one of the
I quit Frost Bank. I was their senior information security architect and moved over to Tesoro as their senior cybersecurity analyst.
We're being recorded. Stop.
Oh, sorry.
Yeah, no. I don't care. It's your information, but it's being recorded.
Got it.
So.
It's okay. It'll be on LinkedIn.
Right. Okay. Yeah, I want to know all of that stuff, but I don't think you want the internet to have it out there in a transcript somewhere.
Oh, got it. By the way, you're going to have to tell me where these wonderful links are. I can't find them.
Oh, you should just be able to go to my Google Plus profile and see them all. Just by following any of the links you receive, it should take you right there. If it doesn't, let me know, and I'll fix it.
Well, okay, because I couldn't find anything last week. I was looking for week 4, and I couldn't find a link to anything.
Last week we didn't have class.
No, I know, but I was trying to go back to week 4.
Oh, okay.
And I couldn't find anything.
Well, I will figure that out then. I'll look at that right now while they're on break.
I mean, I tried the collaborative area, the collaboration area, I tried the forums area, I tried this Google area, and I just don't think I have the right link to get to the recordings.
I'm looking it up right now. I really don't like how it's saying. What was the date? Last week was the
16th or no, I don't know.
It looks like maybe you couldn't find it because maybe it was set to private because it's not showing up on my feed. The last one that's showing up on my feed is February 16th. So I guess no, it is the 16th. So, and you can't see that?
I can't see any of the recordings, so I don't know where the link is to find the recordings.
Try this.
Share it YouTube channel.
Try that.
Under Collaborate, I've been to Collaborate.
No, it's not under Collaborate. I just put a in the text bar.
Yeah, I see it in the text there. I'm going to try that.
Try that, and I'm also going to put the link to the YouTube channel there. Oh. We don't want to do that.
You broke it. This is what I can't find.
Um, okay, I can see the link, or see the stuff there.
And I'm sending you the direct. And here's the actual YouTube channel for the stuff.
Perfect, thank you.
And then I'll send those out in an announcement through Blackboard so it's in your email as well. So that everybody has it. Because I'm sure you're not the only one who had trouble. All right. Other than privacy and other than computer intrusion, intellectual property. For the United States, intellectual property is one of the biggest concerns, and the DMCA is the quintessential piece of legislation around that. There have been other failed pieces of legislation in recent years, especially, and for example, SOPA and PIPA. The Stop Online Piracy Act and what was PIPA? Prevent Internet Piracy Act? I forget. Sounds right. They're both about online piracy, but they were far overreaching because they were citing on the way too much on the part of
Protect IP Act.
protecting intellectual property.
PIP.
Protect
Intellectual Property Act.
What?
Protect Intellectual Property Act.
Protect intellectual property. There you go. Not prevent internet piracy. Although that's basically what it was. They were basically the same act. One of them came from the House of Reps. One of them came from the Senate, if I recall. And they were both aimed at adding additional controls to stop online piracy, because online piracy must absolutely be such a bad thing, right? No torrent can ever be used for good, which is absolutely not true, because torrent is just a protocol. And even Comcast finally admitted that, because Comcast was flagging torrent as a protocol across their networks up until the FCC's new net neutrality rules went into effect. And they said, yes, actually, it's true that you can torrent legitimate things. It's just that it's also used for peer-to-peer sharing of intellectual property and artistic works, right? So first we have to have a basic understanding of what is and is not protectable under intellectual property laws. What is not protectable? That's way easier than what is protectable. What is not protectable under intellectual property laws? Really old things. Shakespeare, not copyrightable. Nobody owns the copyright to Shakespeare anymore. William's been dead for a long time, and all of his work is public. If you want to make your own edition of Shakespeare, you can do that. You just have to leave out the editing comments of other people. You have to find an original, unabridged copy and apply it, or a copy that was made a long time ago prior to its copyright, right? If you can find a book that's old enough that it has no copyright fly page, like say 1897, which, by the way, a William Shakespeare book from 1897 only goes for about $20 a piece. So if you want the whole set, unabridged works, it's a lot of money. But in the meantime, that's cheap. You can republish that all you want. Talk about an easy Kindle self-publish. The unabridged works of William Shakespeare, all you have to do is find digital copies of all of them, or find copies and digitize them. Take the time to do it yourself, because it's out of copyright, right? So really old things are not copyrightable. What else is not copyrightable? Can you illegalize that? So you can't copyright math. You can't patent math. Now there's some question as to whether or not a complex algorithm is a process and therefore patentable and protectable. How you write it down is, and the layout you use is copyrightable if it's unique to you. Google search algorithms, yes, some of them are patented. Bank of America patented the concept of keep the change, is what it was called, where you use your debit card and they would roll over the money back to your account, your savings account, whatever was left over, so it was always even number transactions. Right? They patented that process. It's just math. That's simple money math. But if somebody thought about, hey, we're going to redirect this here, and they get to keep it. And they patented that process. Now, there's lots of frivolous patents, lots of things that probably shouldn't be protected, and that's not what today is about. Okay. Recipes. Recipes are not copyrightable. They're not patentable. Yeah, people are usually surprised. Recipes. Do you know why everybody has a secret recipe? It's because if it ever gets out, you have no recourse. Because you can't stop people from making food. It's just like chemistry. The formula for water is widely known and not protectable. Okay? Nothing you can do about it.
So if I figured out, let's say, Oreo's recipe for their cookie, in whatever way I figure out, I can mass produce. I can't use the name Oreo because Oreo is
And you
copyrighted.
can't use the same mold for the design on the top of the Oreo.
Okay,
But for the composition of the cookie and the cream,
that's
absolutely.
why you have so many knockoff brands.
That's why there's so many, well,
Home brand.
Coke. Coca-Cola, the actual, not the Southern Coke where Coke means soda, but the actual beverage, Coca-Cola. That recipe, not copyrightable, not protectable. That's a trade secret. But it's not protectable by any other means than, say, locking it in a vault. That's a real thing. So, but that's pretty much the list. That's what's not protectable. Okay, that's what's not copyrightable. Basically, every other thing is, if it's not really old, or something that would be publicly available like a recipe, right? Now, the layout on the pages in the cookbook, that's protected. The descriptions of the food, that's protected, right? It's a delicious caramely brown treat for the winter. You have to rewrite that in your own words. That has to be substantially different, right? Or substantively different, not substantially different. So that it's just, you guys all know the rules about paraphrasing and stuff like that. Let's put it in your own words, okay? And sometimes things are going to sound similar, because if you have to cook the biscuits until they're golden brown, how many ways can you say golden brown biscuits?
The lightly brown.
Lightly brown biscuits. Not quite burned biscuits. Whatever, right? But the recipe itself, not copyrightable. These other things that are copyrightable, songs, pictures, art, movies, code.
Source code is.
Or is it? That's a good question, because how many ways in Java can you be expected to write hello world? How many ways can in any language can you be expected to write hello world? Which is, as anybody who's ever, not even just a computer scientist, but anybody who's ever been taught programming in any way in any place knows hello world is the first thing you do in every language so you can get the basic syntax down for the structures, right? I want to make sure it prints something back on the screen to me that says hello world. Not copyrightable.
I have a question. What about like individual words?
Individual words, not copyrightable. Individual words are not copyrightable, but they can be trademarkable. Which is a different thing. So this concept of copyright, there are limits, right? You have to get above a certain threshold of uniqueness. And so a program that makes a calculator, right? Put in your first number, you want to multiply, divide, add, or subtract. Put in your second number, right? That's not copyrightable. The process there is not copyrightable. The code that you use to do that, not necessarily copyrightable, depending on how you did it, right? Because the most straightforward route to do that and accomplish that is straightforward, and every single year one student can do it, right? You hope. You hope that every year one student can do it by the end of the first semester. Okay? But when you start to get to the complication levels of, say, Microsoft Word, there are many ways to skin that cat. And the way you did it, that's your cat. You can copyright that. You can choose how to distribute it, and it becomes property. It is the property of your intellect. It is the product of your intellect, and therefore your property, or Microsoft's property, or whatever and whomever, right? And so once you've made it past that level, and there's no bright line for that level, because it depends on what you're doing. If it's a task that is commonly done, then you probably can't copyright a simple version. If it's a new, unique, new and novel task that you intend to accomplish, to complete, you can probably copyright it. Did you know that patent, which is the physical form, right? The patents are for inventions for new and novel processes. They're the analog to copyright. Did you know that rounded edges on a cell phone were patented by Apple? Did you know that swiping was patented? And seriously, the patent application for swiping looks like somebody stuck their hand on the page, drew a hand turkey, and then put an arrow across the square. Okay, that's what it looked like in round one. And the patent was awarded. Yeah, because conceptually it was new, and so it got awarded. Also, they don't feel like fighting Apple or Samsung, which are the two biggest perpetrators of quick patents, for their, they don't feel like fighting the lawyers, saying, "Come on, guys, really." Because the lawyers will tie their time up and waste it and burn it and whatever. So in copyright is critically important in the age of the internet, because it was less so important in the age of the VHS, where it required equipment, expensive equipment, to massively copy stuff, right? If I wanted to make 1,000 copies of a VHS tape, I had to be committed to that process. Like seriously committed to that process. I had to either buy 100 VHS players, route the cables, wire the system, run enough power to run 100 VHS players, and then I had to sync up all the pushing of the buttons properly, or I had to buy one massive piece of equipment that would do this automatically, which was way expensive. But then this thing called a CD, a compact disc, it came about. Now all of a sudden people are worried, because back in the mixtape day, if anybody remembers the mixtape day, back in the mixtape day it wasn't a big deal because there were one-offs. Maybe you made 5 mixtapes, 5 copies of your tape. And maybe you even had a duplicator that would speed the process up, right? You hit the high-speed duplication mode, and it wouldn't be quite as high quality, and people would buy the original if they liked it enough. But then you get digital media. You get truly digital media, the compact disc. Because now you have lasers. And lasers, man, they're pretty precise. And digital encoding, it sounds good. And when you get raw digital encoding onto a CD and you get 72 minutes of audiophile perfection, and then it comes down to, it can burn in how long? Huh?
2 minutes, 5 minutes.
Originally, it probably, the 2x burner was probably, yeah, so half an hour. And then it was 4x. And 8x, 16, 24, 32. Beyond 32, it starts to get a little shaky in there, literally. And if you haven't seen that, you should go and watch the Mythbusters blow up DVDs. They stick it on a die grinder and they measure the RPMs, and wow, it'll kill you. It will actually kill you if you actually are exposed to an exploding CD from rotational momentum. It's crazy. But you can burn an entire DVD, which is way bigger than a CD, or an entire CD, in seconds, right? 130 seconds? 2 minutes, 10 seconds? Down to 45 seconds for just, a small. It became an issue because mass production became much easier. Copyright infringement became much easier. And we haven't even gone internet yet. Yes, computers, the prices fell. DVD media, and CD media, the prices fell. How much does a CD-ROM cost these days?
I don't know. Where do you buy a CD-ROM nowadays?
Exactly. Because it's gone so cheap. What's that? A Blu-ray burner? Yeah. For $50. There you go. And you can get Blu-rays with 50 gigs or more. 50 gigs. What about flash drives? What's the biggest flash drive? Who's got a 128 gigabyte flash drive? You only have 32?
1 terabyte external hard drive.
Yeah, that's this big. 1 terabyte? Yeah. SanDisk just came out with a 3 terabyte USB drive. This big. Yeah.
How much?
It's amazing. Oh, it's like $500. Nobody's buying that. Come on. Yes, there will be people who buy it. And so, storage is cheap, playback is easy, and then in 1999 there's this thing. And I don't mean the iPod that became a thing. I mean the thing that made the iPod.
Walkman.
No, Walkman's
MP3
just
players?
brand. The MP3.
Yep.
Not the MP3 player, the MP3 format. Okay? Because the Digital Millennium Copyright Act was forward-looking because MP3 didn't exist yet. MP3 came out, and now all of a sudden you could fit a gazillion minutes on one hard disk. And we don't even have terabyte hard disks yet, right? You can fit all of your albums in your pocket.
I
Huge.
remember that.
It was hugely tiny. Yeah, the iPod revolutionized. Now everybody has all this space for music, and everybody loves music. Please don't ever don't ever underestimate people's need for music. You go all the way back to the caveman days, and you will find evidence of eating, sleeping, and art. And art comes in two forms, actually many forms, but there's the draw on things kind, and then there's the dancing around in music kind, making drums and stuff. People have a primal need for music, and this is where that primal need and the digital era met. So now we have the means for distribution, low cost, and high availability. Piracy is natural. In fact, pirates have always been around, right? You go back. Criminals relating to technology is not a new thing. You go all the way back to the road. You get the wheel, you get the road. What do you get on the road? Bandits! You get the railroad. What do you get?
Train robber.
Train robbers! You get the ship?
Pirates.
Pirates. Pick a technology. Pick a transportation medium, and you have the criminal that goes with that transportation medium. Now, if you have ever downloaded an illegal song, you're the pirate. Because that's the transportation medium, and you're the bandit. What? Arg? Yeah. Don't tell me. If you're this person, don't tell me. I'm one of the few people who has actually never illegally downloaded a song. It wasn't on purpose.
Oh, no.
It wasn't on purpose. I just always knew where the streaming sites were, even back when. Right? And my friends had lots of music. I just listened to their music. I didn't need to download it. I didn't need to have it. I was always at their house.
Oh.
Yeah.
Did you take their music to your?
No, they did. I've never owned a standalone. I've never owned one. And all of my favorite music I still have on CD. And my car I have now is the first car I've ever had with a USB in it or a way to get it to it because I've never really cared. Satellite radio, awesome, been addicted forever. Okay, just so you know. So I never had to worry about that because I always got my fix somewhere else. It wasn't intentional. I would have downloaded music in a heartbeat if I had needed to or cared. I just never did. These days I know better. These days, given where I work and what I do, I'm not doing that. And it's only by chance that I never became the pirate. But many of you have become the pirate and are the pirate, and maybe you should think about that. Because there are other people who are thinking about it.
Statute of limitations.
Usually 7 years for theft. So you know. Yeah, the statute of limitations is
See,
usually...
he goes screaming on the
Good to
mountains
go.
now.
Good to go. Yeah. I didn't expect that question. 7 years is usually for theft, just so you know, in most places and jurisdictions. Now, if you leave the jurisdiction and it's a state rule, it's 7 years in residence in some jurisdictions. So, there you go. All right. So what we have now is we have a series of laws aimed at piracy prevention, piracy retaliation, piracy this, piracy that, whatever, right? And there are two ways that they go about this. They go about it through the criminal courts, and they go about it through the civil courts. And the more common is which?
Well, wait.
No, in general, more common across all cases. It's civil court, right? Because you don't have to rely on law enforcement cooperation to take somebody to civil court. You can get your own evidence. You can present them with a letter, and say, you need to pay us this much money because we know you downloaded these songs. Has anybody ever gotten a cease and desist letter from an ISP? Yes, you have. Some of you have, whether you're watching now or you're watching later, some of you have received cease and desist letters. I have never downloaded anything illegal, and I've received a cease and desist letter.
Yeah, my roommates downloaded music
Exactly.
on my provider, so I got one.
Exactly. I got one, and my roommate at the time swore up and down that he didn't download anything. It was Iron Man 2, by the way, before it was out of theaters.
Russian.
Yeah, whatever. But I don't care. I don't care where he got it. What I do know is that he lied to me because not 2 hours later he had the volume turned up, and that sounded a lot like the previews in parts of Iron Man 2 that I had heard. So he got to move out. That's what you get. So this becomes a problem for some legitimate users, right? When Comcast is regulating internally as a non-regulatory body and they're throttling protocols based on protocol. It's also an issue for companies. How much revenue? Anybody want to Google it for me real quick? How much revenue is lost to software piracy or online piracy? Don't just call it software.
Jeez.
Not just software piracy, because that's a specific category of
least
online
million.
piracy. But
A lot.
it's a lot, yeah. But I want to know a number. Just Google it real quick. How much money is lost? Because there's some people are adamantly anti-piracy laws, like across the board. We have these people who don't believe in communism, so they say, but who are very adamant that all information on the internet should be free. 59 billion in the United States or worldwide?
As of May 2011, it was
May 2011, it was 59 billion. So adjust for inflation, and that's much more now.
January 2012, I have an article that said online piracy costs the U.S. economy between 200 and 250 billion per year.
200 to 250 billion, January 2012. And I'll bet if we can find numbers for the in-between years, they just go up. The Digital Millennium Copyright Act, which, remember, is the sole piece of legislation aimed at this, and that is still being used and referenced 20 years later. That's another thing that is hard to wrap my head around, is that the DMCA is 20 years old. Go and search 20 years of DMCA. There's lots of articles talking about the implications of 20 years living under the Digital Millennium Copyright Act. Now, in response to overzealous copyright enforcement, there have been some other movements. Anybody familiar with Lawrence Lessig? Because I specifically suggested, though I did not mean to mandate, that you buy his books.
Is that one of the ones that's under required textbooks?
Yes, because
Yeah.
they make
Then I have it because
There
I
you
got
go.
it.
Lawrence Lessig
Yeah,
is the
no.
author of the required textbook.
I didn't read it, but I have it.
Yeah. So the story behind that, just saying, now I'm supposed to pick a book, and they find it as required when it's suggested. Those are great books. I didn't suggest crappy books. They just aren't specifically required.
They also weren't rentable, so I
You know
own
what's
it
special,
until
right?
I'm
You're gonna
Yeah.
have to expect
the energy to actually go
Yeah.
install it.
And so Lawrence Lessig, it talks about code as the law of the internet, as code as the expression medium of the internet, code as everything, right? Code, programming code, not legal code, but programming code, runs our lives now. Anybody have a digital thermostat at home?
Oh, yeah. I have a Wi-Fi connected one.
Yours is very digital,
Those are fun.
No.
very digital, right? There's code inside of there that keeps it working. I lost you. Chris is back. Jennifer's back. Chris never left. There's code in there that keeps it working. Code that is protected by the Digital Millennium Copyright Act, if they want to keep it secure. Anybody ever modify a car?
I don't, my brother.
Does he? What kind of cars does he modify?
Just try.
His truck. That's pretty common. The chips. Wait a second. What's on chips? Code. There's a new push as of late last year by automobile manufacturers to prevent based on the DMCA, which it was never. The DMCA was never aimed at cars. That doesn't prevent its application to cars once cars become walking computers or rolling computers. They don't walk.
What year is the DSC?
1996 is when it went into law. It was passed in 1995. Yeah.
Cars didn't.
No, cars did have a couple chips. They had finalized the type of connector they were going to use for the next 30 years. ODV2 or whatever it is. All right, allergies are so bad. Yeah, they're trying to apply the DMCA to cars. They're trying to apply the DMCA to anything with a chip, even though everything has a chip now, right? The mechanical watch or digital? Does it have analog?
Yeah.
Good for you.
Digital.
Digital.
I can't read watches well enough.
Degree in math, can't read a clock.
Yep.
Okay. They think you're managing the story. All right. Other facets of the DMCA, direct name and privacy. Have you read about the case where the MPAA went after the woman in New York because her daughter had downloaded some songs? I think it was her daughter or her son. Her underage child, without her permission or consent or knowledge, downloaded some songs, and they received a letter demanding $260,000.
Ooh.
$260,000 in licensing fees and penalties. There's no regulatory framework around that, so you know. This is just what they're arbitrarily demanding to make an example out of somebody, and they pick on a single mom and her kid. Made bad headlines.
I wonder how long that daughter was grounded for.
Yeah, no kidding.
You're not
So-
touching a computer ever again.
Yeah.
It's clear that there's been some misuse of all the laws we're going to talk about this semester. Okay, there you can find ways that laws have been abused, misused, misapplied in all these cases. But there's also a clear case for the need, just like Mark said earlier, for regulation. Now Jennifer is a proponent of applying the regulations we have, and Mark said that we don't have the laws that can that apply.
20-year-old
Well, they're 20-year-old laws,
or older.
but they're not enough. Or older. 1986 is the previous one.
40-year-old.
That's a 40-year-old law. But
Oh,
that's a 30-year-old law.
30-year-old.
It's a 30-year-old law. Absolutely. So the question is do we work to figure out how to apply the old laws and find out how to apply them reasonably, even-handedly, fairly, etc.? Or do we craft new laws with the aim of making them reasonable, even-handed, and effective? Taking piracy, for example. What is a fitting punishment? Because we know what a fitting punishment for murder is. Now, we have some debates as to how extreme that punishment is, but we recognize that penalties of law do apply to murderers. We recognize that penalties of law apply to violent offenders. We recognize that penalties of law apply to the Bernie Madoffs of the world who rob billions of dollars from people and ruin people's lives. We recognize that. What about the overzealous teenager that just gets into a system to see if they can? What about the, I don't know, what about identity theft that only causes $50 in damage? What about identity theft that only causes $500 in damage? What about when it causes 1,000, 10,000, 100,000? Where's the bright line, and is there a bright line? Do we treat them all equally? Now, under physical theft laws, we have petty theft, theft, and grand theft, depending on what jurisdictions you're in. There are distinctions made, right? Sometimes it's larceny, sometimes it's theft, sometimes it's burglary, and those all have different connotations, right? But what are the digital equivalents? Because trespassing is easy. You walk into my house, you're trespassing. What about if you break into my Nest thermostat and turn up my heater? Huh?
It's an invasion of your privacy.
Well, it's an invasion of your privacy.
You just
Maybe it's
increase the
possibly-
heating bill.
It's trespassing according to the 1986 Fraud and Abuse Act, or at least it's a violation of the Computer Fraud and Abuse Act. But maybe it's also vandalism.
Theft.
After you're increases your electric bill.
Yeah.
It's at least breaking.
It's at least breaking and entering. Okay, cool. We don't have laws to adequately address this. Because if you, right now, if I had a Nest, which I don't, if I had a Nest and you wanted to break into it right now, we're in the same jurisdiction. It's unlikely that your signal crosses state lines, so it's not a federal matter. How are you going to get punished? How are you going to get caught? You're probably not. Unless you're stupid enough to leave me an Easter egg saying, hey, hey, I got your Nest.
Hi, Andy.
It was me.
You're just sitting there confused, like.
Yes. I'm probably not confused. I probably know exactly what happened, which is why I don't have a Nest. Because I'm a target. I'm a walking, talking target for that kind of stuff. Every time I present at a conference or win an award, I have to be on the lookout for 6 months for fake identities on my Facebook. Yeah, I've had to have 6 of them taken down. So I'm a walking, talking target. No connected systems for me. Because my students probably couldn't help themselves, and I don't want to send my students to jail for doing something stupid even though I told them not to. I'm mostly referring to my undergrad. He was once one of my undergrads. He didn't do it, but he watched it happen. The thing that he's laughing at. So, given that the economic loss, there's a clear imperative for having laws on the books. But given the abuse of the laws and the threat of using those laws, because the MPAA is not a regulatory body, but they act like they are when they send those rules. And they use the DMCA as a threatening block. They threaten to press charges in criminal court if you don't capitulate to their demands in civil court, which is an option in the U.S. legal system. Maybe it shouldn't be in these cases. If you choose to exercise your civil rights to civil proceedings prior to criminal actions or criminal charges being brought by a police department, maybe you waive your rights to press those charges. I don't know, because I'm not the one making laws here. But it needs to be considered that these are the issues that we're going to have to deal with. And I also need to consider what other laws might be applicable. What other laws have a direct impact on how we behave online. See where this is going? Mm-hmm. And so there's lots of little instances like that child in New York, like the teenager gaining access to systems, like a company losing billions of dollars. I brought up Lawrence Lessig because Lawrence Lessig was a founder of something called the Creative Commons. Anybody know what the Creative Commons is? It's a new designation under copyright. And it's a specific license that people who sign on to the Creative Commons agree to abide by. And it has various levels. Creative Commons share and share alike is, I have no restrictions on it, I created it, and I place it there for public use. Because one of the tenets of creativity is that the reason things that are very old go out of copyright and become available for use by anybody is so that other people can build on that creative work. And you take that foundation and use it to build something new and better, which is then copyrightable again. And that process is supposed to build on one another. How many books have you ever read that were analogs of, or movies that you've seen that were analogs of Romeo and Juliet? No new plots. We've pretty much run out, so we recycle a couple, and you can identify them, right? Macbeth, constantly recycled. All it is a traitorous family, right? The Oedipus complex, that's a very old one. Some of those Greek stories never go out of style. Sorry, my allergies. And so what I'm interested in here for the next, and I am not going to give you an assignment that's going to be due over spring break that you have to work on over spring break. I think that's horrible, and some of your other professors are probably going to do it to you. So I won't, because this would be the part where I start to introduce what our next assignment might end up being. Okay? We are going to have another assignment right after spring break, and it will be a combination of privacy and intellectual property, combined probably with the cyberbullying stuff. because we're going to move this to cyberbullying, hate speech, and social groups, social movements, social media as a tool for all of the above, and various laws, statutes, and case precedents associated. That's what we're going to cover right after spring break. And I'm going to rewatch this right before class to make sure I don't miss any of this. Any questions, comments, or concerns so far regarding privacy and intellectual property? Okay. And after we get done with the cyberbullying, hate speech, and whatnot, we tie it back into privacy and intellectual property because they're all related concepts. Then we're going to move on to net neutrality and freedom of information.
What is like
Ooh, in which thing?
intellectual property?
Intellectual property. YouTube is shielded from liability for intellectual property because they comply with DMCA requests for takedowns out of hand. They have in recent years become better at introducing due process so that you have a way to appeal. For example, somebody claimed that a video of my dog was their video, and they were reusing it and recycling it and all kinds of other stuff, and so I had to submit that no, that really is my dog, and I showed that my upload predated their upload, various other things, and I got my dog back, and I also took all their revenue.
Was it much?
No, it was
Okay.
19 cents,
Okay.
something like that. It's something tiny. That's a principle of the matter.
Yeah.
Right? I mean,
I know the law.
what's that?
I know the law.
No, that's, yeah. No, that's my dog. That's really what it is, okay? But they avoid the liability associated with copyright infringement by complying with requests from copyright holders. There's also a whole lot of issues that we're going to get into around corporations versus persons owning. Okay? So YouTube has what they call the standard YouTube license, which is loosely modeled on the Creative Commons, which is if you put it up on YouTube, everybody's allowed to watch it if you make it available. If you take it down, if you unlist it, you're the controller. But that doesn't stop other people who, while it was up and available for use, if you mark it as standard YouTube license or if you mark it as share and share alike in Creative Commons, if you put it in Creative Commons and somebody else uses it after that, you don't have any recourse and they keep a record. If you don't put it in Creative Commons and other people use it, you can get it back. But they're not liable for privacy or anything like that because they comply. And that's how they get around it. Otherwise, yes. And the SOPA, PIPA, and one of the more recent failed ones, they were going to give the Department of Homeland Security the right and the ability to hold service providers liable for the content on their website. So, for example, YouTube would be liable for the content uploaded by all of their subscribers.
So if somebody uploaded like child pornography,
They could just take
if
YouTube.
it wasn't taken down
They
in
could take
time,
YouTube down for no, not in time. Period. Like if it
oh,
ever went up, they could take YouTube down in whole. So that bill didn't go.
Yeah.
But they tried to, and they will try again.
Yeah.
That battle's not over. Holding who's accountable. Later on in the semester, we're going to talk about who's accountability, and we're also going to talk about liability. And we're going to talk about, and I'm so glad the Google car finally hit somebody.
Did it?
oh,
You
it
know
did.
what? Nobody was hurt, so I'm allowed to be glad about this. But the Google car, they can't hide it. It happened in public. And so we finally get to start having this discussion in a non-hypothetical sense, which is under liability. Whose fault is it? Okay. Now they're just gonna write a check, and that's not a big deal. But we're gonna get started. Okay.
All
It
right.
happened.
I'm in the middle of a book, I can't remember what it's called, but about terms and conditions, basically. And one of the best things I read from the book was that Google Docs, they have in their terms and conditions that the stuff you publish, like on Google Docs, you make on Google Docs is technically their property. And is that not right? In the terms and
Not
conditions?
how I read. It's that they have free use of it for their algorithms.
Okay. So they
Yes.
can't actually claim
They're allowed.
ownership.
They can't claim ownership for reproduction purposes,
Mhm.
but they can claim ownership in terms of they don't have to pay you to use it to make money off of you. Meaning, if you have information that helps their algorithm be more efficient,
Okay.
they're allowed to use it.
Okay.
Okay? So it's not quite the same thing, But their automated services are allowed access to your information in its entirety, and that's how they know what ads to show you that you might actually click on, which is the sole way they make money.
It's always freaky because you like Google something and then like 10 minutes later you're reading a blog and there's an ad for that thing you
There it
looked up on
is.
Amazon.
That's right. That's right. All right. No assignment this week. I want everybody to get all caught up and to enjoy their spring break.
We have assignment next week, right?
Huh?
We have assignment due next week?
I'm going to push that due date back to the week after spring break so that you
All
don't have to. Yeah, no. I do not believe in working over spring break.
Thank you.
It's like a college religious holiday. Okay?
I was so stressed.
Yeah, I'm allowed to make you. I don't feel right doing it. So,
But
To clarify for those of us online, which assignment are you pushing back to be due the week after spring break?
Testimony?
yeah, the expert testimony case briefs.
Okay.
Or case brief. You're supposed to read all the cases and.
Is that posted yet? When was that
It
posted?
was-
I just said it.
Oh, okay.
It was an email that went out last week.
Yeah.
Okay, I didn't.
It wasn't actually
I was
posted
guessing
yet.
I hadn't seen the actual assignment posting yet, so
No,
I was like,
no,
was there a due
You
date?
can't turn it in yet.
Okay,
I gave you the assignment in your
Okay.
email.
I knew that. I just didn't
Yeah.
know like what the
No,
due date
You
was.
can't turn it in yet. I have it in most of the Dropbox, so that nobody can try to get all, like, proactive, get ahead. You need to enjoy your spring break. You have to take downtime.
Absolutely.
Are you allowed to write to all our other teachers and say that they need downtime?
Well, yeah, you're allowed to do whatever you want. You have the First Amendment right to do that.
Hmm.
And I have no control over.
And they have the
or-
First
or in-
Amendment right to give
Or
us a zero on
indictment.
that.
I have no control over or indictment of their reasons for having you do work or not. I only know where I stand on that issue. So, yeah, there will be, the due date, because I didn't look at the calendar when I set that date. I just did my normal 2-week roll. So I'll push that back, and your next assignment will be assigned when we get back from spring break. Okay? Thank you. And it will be over this material and the material we covered that week. Any other questions? Jennifer, do you have any other questions right now? And then we'll stay afterwards and cover that other stuff.
No, I'm good right now.
Okay. Anybody else? Chris?
No, I'm good, thank you.
I think I'm going to call you just Mr. Jones from now on.
Hey, that'll work.
Yeah. Counting Crows played here in 2001, I believe. It was a great concert.
Oh, that's cool.
It was. It really was. All right. Hearing no objections, get out of here. Enjoy your spring break. And then I'll talk to Jennifer, and then I'll get out of here, and she'll go do whatever she does.
Andy,
Enjoy yours.
Yeah, what's up?
Just come here.
I'm going to stop the broadcast so that we're offline and not recording anymore.